Good evening, everyone. I'm grateful to Y20 and Shama Prasad Mukherjee Foundation for inviting me for this discussion. Uh, Shamendu, having said that I happen to be a bar representative, so I am generally expected to speak more on the aspect that we must first stall things and then start discussing how to get it right. In this, Shamendu, where you rightly said, there seemed to be some kind of haste, in my opinion, in bringing in these rules. Apparently, the dates have some coincidence. It's March 2018 when the judgment was delivered, and apparently, some kind of 5 year period was lapsing. And the Bar Council of India, though it claims to have done it with the consultation with the stakeholders, but hardly any stakeholder has actually commented on it. I may not be against the move of allowing the foreign lawyers to come in, but the rules as framed and even the clarification leaves much to be desired, because there is not just the fact that the discussion in the statement of objects and reasons talk only of United Kingdom and they permitting visiting advocates on a single case basis, have sweeping statement of allowing Indian foreign lawyers to come into India on a reciprocal basis. Now that reciprocity is somehow missing. The rules as drafted and as clarified say that these foreign lawyers cannot step in wherever there is or present their cases as lawyers when there is or whichever forum or tribunal which has evidence to be recorded. But at the same time and same breath, it talks of appearing in international arbitrations and tribunals of which are dealing with international arbitration. Again, a contradiction of sorts, because there also evidence is recorded. It talks of engaging lawyers, and to my understanding and my belief, most of these foreign law firms by proxy are already in India and operating in India under some name, some fancy name which doesn't connect to their company directly, but they are already there. And as an aspect which affects most lawyers and mostly most lawyers in India is that the registration and governance of their and misconduct, etc., the disciplinary, etc., is all with the Bar Council of India. Whereas the state bar councils, which are directly connected to the bar and the members practicing, are not in the loop. And the disciplinary action can only be taken if the BCI comes to the conclusion that there is a quote unquote substantive misconduct, which somehow is as vague as possible and doesn't gel with the Advocates Act, which governs us. And on the nitty gritties, one would find a lot of things which are vague. We don't know what's the qualification which is required, because they say that whatever the primary place, the primary country where they are qualified to practice as lawyers will govern their entry into India. Now that's again, I don't know. We have qualified with so many exams. How far are they studying and what all do they study? We don't know. Another aspect is, at least the three of us here as seniors and several on that side would find being designated a senior, here the full court decides. And God knows what's the system followed there. Because if you are, whatever designation you are there, you immediately get it here. Now, that quid pro quo and what kind of a reciprocity is there is somehow, it's all vague in the thing. So, as far as I am concerned, even if the purpose is salutary, the rules on the ground are highly vague and are probably lopsided, trying to favor them, to which I will definitely be against.
Thank you, sir. Jain, sir, would you agree that these rules are much left to be desired and these are lopsided? And how would you look at these rules or these recent developments that have happened?
Good evening, all. Coming straight to the point, I tend to agree with what Mr. Mathur very clearly and eminently expressed. I also find that the rules are perhaps they should have been debated before they were made. And there is a lot of confusion, there's a lot of vagueness in the rules, and it should be revisited. But let's approach it from something very basic. And I think that's important. Let's not miss the woods for the trees. I ask myself the first question, which is that is the interaction between Indian lawyers and the foreign lawyers, which is an inevitable conclusion of this exercise, something which is bad or something which would subserve the professional standards in India? Having practiced for some time, not of course as much as my co-panelists here, I feel that such a close interaction would certainly and without any doubt help us to prepare ourselves better. As our economy expands and more Indian companies trade with and operate their businesses abroad, there is no doubt that we are sitting on a keg, a powder keg of legal issues troubling Indian businesses or facing Indian businesses. Now, what happens typically when an Indian business is litigating abroad or in an international arbitration against a foreign partner? More often than not, you will find the proceedings taking place in a neutral territory, so-called neutral territory, which inevitably happens to be in Europe, if not almost on most occasions in London, or possibly on some occasions in Singapore. You also find that inevitably the adjudicators are foreign judges with little or no knowledge of Indian law. And more importantly, I'm not speaking about the racial and other prejudices which creep in the decision making. It is important, therefore, to increase the interaction so as to ensure that they know what we are made of, and the Indian businesses confidently can engage Indian lawyers to represent them. As of now, inevitably, Indian businesses, alongside an Indian legal team, have to hire a foreign law firm, which they feel would undo the racial prejudice or a white favoring a white notion. So, all of keeping that in mind, I think the important aspect and the time for this idea has come that we must increase the interaction between the foreign law firms and the Indian lawyers and law firms. It would certainly help us better our professional standards, better our professional experiences, and prepare us for an onslaught of legal issues which is waiting to happen. However, even the best of things must always be done with not just the best intentions, but in the best way possible. And I don't think the formulation of these rules has been done in a way that can be called best way possible at all. There is, as Mr. Mathur said, there is only mention in the preamble, only mention of the UK solicitors authority allowing Indian lawyers to appear in the UK. Now, the question arises: suppose they do allow, in principle, we know how the Indian lawyers who go from here to practice in the UK, the amount of prejudice in some sense they have to face, you will find hardly anybody practicing full time in a court of law there. Even those who go from here to practice and to join foreign law firms are sitting with them on their Indian legal platform, where they are helping those law firms deal with clients who have an India exposure. Therefore, how does Bar Council of India ensure that the counterparts of Bar Council of India do ensure, not just in principle but also in practice, that Indian lawyers are allowed to practice on reciprocity in those jurisdictions, not just in principle but also in practice? Unless we have a mechanism of ensuring that, I don't think it will be fair to open in such vague, uncertain, and perhaps to a large extent without any deliberation, without any discussion, without any debate, in such a manner to allow them to come in. I am not calling it a floodgate, because I am sure as youth, as lawyers, we are capable of dealing any amount of floodgates. But to allow someone to come in and practice in India is something that must be approached with caution. It must be approached with clear expression in the rules, which presently they don't have.
Thank you so much, sir. Priya ma'am, you've had some experience working on these rules or with the Bar Council. Given by what Mr. Mathur and Mr. Mehta have said, there is somewhat vagueness in how these rules have been framed. Do you look at it in a similar manner, or do you have a different take on this?
First of all, I would like to say that there are two aspects to which we need to look at. In most of the foreign jurisdictions, they work mostly on the basis of law firms and chambers. In India, we are mostly individual litigating lawyers on one side, and some of the law firms and a lot of young lawyers who are setting up their law firms. So we do have that distinction that we have litigating lawyers more in majority than the law firms in India. And the Indian lawyers are most sought after in the international jurisdictions, from what my experience is. You find a lot of young lawyers who have joined law firms there and are doing extremely well, and not only that, they are advising them on the legal laws. Recently, we had a conference in Goa of the Commonwealth Lawyers Association, where Mr. Santhanam is here and Mr. Arunesha Gupta here, where we all participated in it. And as we all follow the Commonwealth laws and the legal system, there has been a lot of talk about setting up a kind of a association or a commission which from each jurisdiction, which could give in their inputs on what should be the common platforms where we work on. And as Mohit rightly said, the Bar Council of India has really been in haste and not actually consulted the stakeholders, which should have happened, because we all are in some way or the other involved in these kind of dialogues, but at different levels. So at the Commonwealth level, where we all are governed by, I think there is something we could look at, put together. As Mohit said, we could talk to the state bar councils and bring out a common platform. As far as I had an experience of interning with a law firm in England way back in 1997. And I can tell you with great pride, Indian lawyers are far, far superior, far, far more smarter than the lawyers which I came across at that point in time with the law firms. So we have the expertise, we have the knowledge, we have our own, the law firms, law colleges that we come from in different, not only the National Law School, but other law colleges as well. But somewhere what we lack, and I feel, is that we lack a sense of discipline, a lack of, continuing legal education, mentoring. We do not have. When we have first generation lawyers coming into the profession, they don't know where to go. They don't know where to look up to. And I think that's where we need to put our house in order. We have to set up mentoring cells. We need to handhold young lawyers who come into the profession to guide them as to what their interests are and what they can do. and everybody who comes into the profession. See, when you're looking at law firms coming into this country, you're looking at very good pay packages. You will look at collaborations of young, small law firms with the bigger law firms. That is why here is what, before all this happens, is we need to put our house in order and help our lawyers stand up to a minimum standard. As Mr. Jethmalani said, ethics and our conscience is the most important aspect that we have to work on. That is something where we are slipping. Across the country, we are slipping on that. So ethics is something I would, speak to each and every young lawyer and say, you must maintain the highest standard of ethics towards your colleague, towards the court, and towards your client. That's what is most important. Coming back to what my field, I think it's important that we talk about foreign lawyers coming into this system, because I can tell you that we would be far better, and we have the talent amongst our youth, in the youth of in the Indian legal profession, who would be doing wonders in the law firms if they are taken on board. But reciprocity is a huge issue. I can tell you from UK's perspective, there are only very certain aspects where you can work in. You can't do majority of the work in the UK courts. And the many issues that Mohit has mentioned, I endorse that. And I think we really need to have, under your banner, a conference where we can go through the rules, look at international standards which are there, and then come forward with suggestions to the Bar Council. Thank you.
Thank you, ma'am. Apurva, I'll just like to channelize this discussion towards a Y20 theme. We are under a Y20 banner. The objective is to see how India can contribute to the global landscape and what is there for India as a contributor. A lot of talk has happened to develop India as an arbitration hub. And now that in the year of the summit, the India being developed as a center of arbitration, say a London or a Singapore. So do you think these rules actually assist, facilitate towards that objective, or you still think that still a lot needs to be done to maybe achieve that objective to develop India as an arbitration hub? For someone who has been part or is a regular participant in arbitrations all over the world, what is your take on this? So that there is something for the Y20 representatives to maybe obtain or have from these discussions that we have or we plan to have in the near future.
Thank you, Shamindu. I think the way to look at this problem is that it is a situation where we did not have the experience or the exposure for Indian lawyers in international arbitration before all the new legislations of the Delhi International Arbitration Center or our Arbitration Act was amended to bring in new opportunities. Now, there is some vagueness about what the rule actually provide. For instance, if you look at the arbitration clause, it says that foreign lawyers can provide arbitration advice, but at the same time, Indian clients seem to be prevented from engaging a foreign lawyer if there is a foreign law involved. So there is some doubt about how the Bar Council would actually clarify these rules. But having said that, when foreign law firms enter India, and we'll see how things materialize, the international arbitrations that they deal with, the sheer size or scale of the international arbitrations that they deal with, actually has several cooperating lawyers in different jurisdictions. There could be multilateral disputes between entities in India and the United States or the UK. And these disputes actually require cooperation between several teams of lawyers. My experience, having worked in a law firm in the United States, for instance, is that these disputes actually don't have lawyers who work in silos. They work in large teams across jurisdictions. And therefore, when we talk about international arbitrations, it gives an exposure to our lawyers here, Indian lawyers here, who would otherwise not have had these opportunities to be part of these large teams. So our youth is actually looking for the opportunity to prove its mettle in the world stage. And when these law firms actually have the opportunity to establish their offices here, there is obviously a very tailored system which is there. There are limited areas in which they can provide advice. There are limited areas of arbitration. But the fact remains that it provides an opportunity for our young graduates in India who would be graduating out of the national law schools like you, or the 5-year courses, who would otherwise not have an opportunity unless they go abroad and work with these international law firms to deal with complex arbitration cases. It seems that the rules need to be looked at from the perspective of a platform. One could clarify it, one could improve on it, one could amend it. That's for times to come. But at the moment, the way to look at it would be that it's a platform which these rules provide for all these international arbitrations or international transactions to be brought here. These are already happening. The international transactions are already happening with or without our lawyers being involved. The international arbitrations are happening across the world with or without our lawyers being involved. And our businesses are involved in that. I had an opportunity to just ask the ICC, the International Chamber of Commerce, since I do a fair bit of ICC arbitrations, on the number of arbitrations which are India-seated. And the figure in 2021, I believe, is about 19, which is staggeringly low. Despite the regulatory framework that we have, despite the Arbitration Act having been there since 1996, the ICC is one of the biggest platforms for international arbitration, and only 16 or 17 India-seated arbitrations. So this would perhaps bring in, with some more clarity from the Bar Council, obviously, but would perhaps incentivize Indian businesses who have disputes with foreign clients to push for India to be the seat of the arbitration. And a lot of our businesses have that bargaining power now, whether the largest conglomerates that we have do have that bargaining power. They push for Indian law to be the dispute resolution law. And they can then push for India to also be the seat of arbitration. That opens up the market for Indian lawyers who can collaborate and work with these foreign law firms as part of the exemptions which are provided under these rules in their India offices. That leads to not only efficiency in legal advice, but also cost savings, both for Indian businesses and the foreign businesses, which would otherwise not be available to us in the sphere of arbitration or international transactions. So I think the way to look at it is in management terms, what is called a with or without argument. Are we better off with these law firms, or are we better off without these law firms? If we look at it as a platform for bringing in that work which is otherwise happening out of India into our domestic markets, this is actually, in my view, a situation where with law firms, foreign law firms, we may actually be better off, provided the tailored protections which are there for our domestic bar is actually enforced. And there, I think I agree with my co-panelists that there is some vagueness on how that is going to be enforced, how that is going to be actually monitored and ensured.
Now, because we are short on time, we'll just do one more round, and we'll actually look for solutions, because all of you have this common point of view that there is some hasteness and probably things could have been done in a much better manner. So Mohit sir, if you would like to supplement after hearing all your co-panelists, if you have something to add, we would be glad to hear you, and probably suggest some things which could have been done in a better manner, that maybe that could be taken and worked on further.
In fact, the perspective given by Apur and Jan to that extent, that it helps in increasing our efficiency and opening wider horizons. I may tend to agree with that. But I, in fact, wholeheartedly endorse what Priya said. There's some kind of a misgiving that people think just because they are that foreign tag is there, they're better. Who says that? Have we not seen across the board every academic contest anywhere in the world, and some Indian or the other, or Indian origin, is the one who's winning it? Why do we have this notion that Gori Chamdi is going to come us and give us and teach us how we should practice law? What are we here for? I agree with Priya. 99% of the time you'll find we are better off. And why are we only looking at this tag of international arbitrations? Are they coming here only for that? If they're coming only for that, then the rules should have been only for that. Rules are opening it for all transaction business, all courts and tribunals. You can engage lawyers to do that work. So they become masters and they want us to work, or our lawyers are youngsters, and you are the platform, you are Y20. Why is our youth, we are not shy of the competition. Open your doors. You want to open our doors, you open your doors simultaneously. The example given is only of England. That's why I pointed it out. And I've been saying it on different platforms. The only example you have given in this entire statement of objects and reasons is England, UK. You open your doors and we'll tell you, we'll show you how there is a reverse of the business. Our people are competent and confident. Don't we find that our 5-year graduate from here, when he goes and does his LLM, just 1 year of their exam, and the top bracket is all Asians. All the academic exam. At least I can say confidently, I interact with youngsters on a daily basis. They are far more focused, they are far more clear-headed, and they will outshine all these foreign law firms. So yes, if we are looking at they giving us business, fine, I'm open with it. I'm accepting it. But please open your country's door for us. Then we'll show you. Then you don't need these rules. Open it fully. We are game. Who says we are fearing? We are far better than them. Yes, I agree with Priya. We definitely lack this. We have this crab mentality. We don't let our own people grow. If mentoring is done properly, as they have their chambers and they have their law firms, yes, if we mentor our people, we handhold them. And in that regard, I have been saying as a representative of the bar, even the judiciary needs to step its work towards handholding the juniors. Don't scold them, don't reprimand them openly. Handhold them, nourish them, nurture them, and you'll find we are far better. And I am confident. I would say throw these rules into the dustbin, open it. But then at the same time, open it that they will have a reciprocal arrangement. Those countries should come and say that yes, our law firm is coming in and we are accepting your law firms also. I'm fine.
Priya ma'am, do you think that as a possibility of what Mohit sir is saying, that foreign firms and foreign jurisdictions should allow their doors to be opened up? Do you see that as a possibility in the near future?
Absolutely, it is a possibility. I don't think there should be any reason for it not to happen. But again, I have one small. I would not. Maybe a caveat is not actually the right word, but see, in most of the jurisdictions that I have been associated with, and mostly in the Commonwealth law jurisdictions, every year, all the lawyers go through training programs, enhancing their skills, whether it was skills on cross-examination, leading evidence, art of arguments in court. But in India, and that's the saddest part of where I really think the bar councils really should step in, is do continuing legal education every year. It must be compulsory that one weekend, just one weekend, every young lawyer must go through some kind of a enhancing their skills training program, which we run, which I know we do. Mohit knows about it. We have run it in the high courts. We have run it all over, just to enhance your skills. Law is, we are still learning. Every day we learn. I learn a lot from young lawyers in the court. When they argue so well, they're appreciated by the courts as well. And we sitting at the back also think say that, you wow, this gentleman or this young lady argued so well in court today. So, but this is where we are lacking. We have so many people who graduate but who are not in active practice. I think the bar councils should have these demarcations. Non-practicing lawyers, they may not be, they may be, they may have a certain amount of fee, but they are known as non-practicing lawyers. Practicing lawyers who are practicing daily in courts or in law firms should have a separate tag, and you renew your membership every year, not I'm saying by money, but by enhancing your skills. We need to discipline ourselves, we need to regulate ourselves, we need to have continuing legal education to be at par with any other law firm or any other lawyer of any country. That's what I would add.
Thank you, ma'am. Jayan sir, for a young law graduate who's just come out of law school, he sees around him so many colleges cropping up, many abundant supply of new graduates who are coming into the legal system every day. Now with these new rules, and everyone is saying there is no clarity as such. So through the eyes of a young lawyer or a young law graduate, how should he see these rules, or how should he foresee the future that stands before him with foreign firms coming? Should he or she consider it as a threat, or, as we say, are these new frontiers for the young law graduates?
I would call it as a frontier. Yes, we need to equip ourselves better. There's no doubt about it. But I'll give you an example. So when I joined the profession, there were hardly very few international arbitrations where Indian lawyers were engaged or they were representing. Invariably, an Indian client would engage a foreign law firm. That is changing, and that's changing for the better. I did 2 international arbitrations last year, and I'll give an example of one of them. In one of them, the arbitrator was a QC from England, now KC, of course. And opposite party was a Canadian party. They had engaged in English law firm. And on the Indian side, I was representing the team. I will pick up 2 points, one positive and a negative. A positive point, which I must credit those lawyers, was that they were involved from the very inception. They were very methodical, they were well prepared, no doubt about it. In terms of sheer level of preparation, I think their level of preparation is far better. There is no doubt about it. Let's not kid ourselves. So we need to learn and imbibe that. If we have to perform at the world stage, we should be equipped, we should be competent to do that. A negative. While they were well prepared, they couldn't think as fast as an Indian lawyer does on the feet, because we are trained to deal with practical issues, practical problems, and quickly find a solution to them and move on. So we had an advantage. Now, you could call it an advantage, and I'm not praising myself, it's about the team that I worked with. It was an advantage of merit. So in terms of sheer merit, apple-to-apple comparison, our Indian lawyers are far better. However, we should not be hares, because it's the tortoise which ultimately won the race. So we must complement our merit with better preparation. And that's where I think Ms. Hingurani makes a very, very important point. And I would say it's not only for the young, it's for the bar across ages and across generations. All of us, we need to revisit, we need to re-equip ourselves. And I think one aspect that the Bar Council of India must look at is to integrate practicing lawyers with academics. You have today an iron wall. A law teacher can't practice and a practicing lawyer can't teach. Unless you have this barrier gone, you will not have good practicing lawyers going back to these academic institutions sharing their experiences, their knowledge, their competence, their standing, and their knowledge with the young. And the young would, when they come out of the law school, they will have to start from, say, below zero, because they don't have much of a practical insight except through internships. So yes, better equipping ourselves across ages is certainly an idea that I feel should be imbibed immediately. But for the young, because your question was about the young, I feel that this is an enormous opportunity. It is an enormous opportunity to showcase your talent on the world stage. It is an enormous opportunity because we have great pool of young talent. We have a great pool of lawyers, and the college that you do your law from. Although I am from NLS, and there is an impression that if you're from a law school, then you're better received. Maybe, maybe not. But I think that time is gone. Today, if you are a competent lawyer, no one asks you. People first look at your work and then they ask you as to where have you done your law from. They don't ask you where have you done your law from and then look at your work. At least I practice that, and I've seen enormous number of my friends do that. It's your work, it's your output, and it's your quality that matters. So if you are a young lawyer, regardless of which college are you coming from, willing to take risks, willing to put your neck out and give out quality, yours is the earth and everything that's in it.
Apur sir, closing thoughts, then we'll move on to our next panel discussion.
I think the way I would look at it is the sole objective would be, does it help our young members of the bar? Do these opportunities help our businesses and our young members of the bar? If they open up avenues, then that's a good thing, with proper regulation, with proper enforcement. If they don't open up avenues, and we'll have to see how these rules actually work out. It's nice to have rules, but we don't know how they will actually work out in the years to come. If they don't open up avenues, and our lawyers are actually excluded from all the work that comes in, and it is in closed rooms or silos that foreign lawyers and law firms do their work, then that's not a good thing for us. So the litmus test would be, would our young lawyers find new avenues and opportunities when they graduate, other than Indian law firms or the courtrooms or corporate offices, in these new avenues which these foreign law firms would likely bring into this country? If it does, then our youth has something to look forward to. And if it doesn't, then we'll have to think about it as to what went wrong in these rules.
Can I just
Please.
you asked the panelists, what is the future? What do you say? What do you think Y20 at the end, when we are finishing with the presidency of G20? What suggestion or solution do you think we should have? I would recommend that we would have an Indian lawyers judicial, like an academy, like we have the National Judicial Academy for the judges, and where they go in for training, whether it is district judges or high court judges or even for the Supreme Court judges. Why can't we pitch for an academy for lawyers where we ask on them to come regularly, to come and enhance their skills in every branch of law? So I think I would pitch for that.